Good evening, friends. I, on behalf of Beyond Law CLC, welcome you all. And it's a different type of feeling on a Monday for a professional, because after a weekend, to get into the grooves, and especially during these testing times, has its own feeling. And in Madras, as we all know, that they are both multiple, that is the physical as well as the virtual courts. So we will ask at the end of the webinar as how is the experience after all these times. And it seems that Mr. Prabhakar, straight from his physical court, has straight away joined us to share his knowledge on the topic of presumption. In the case of will, specific reference to section 90 of the Indian Evidence Act. As we all know that section 90 of the Indian Evidence Act has its own relevance, and more specifically for the purposes of will, as to what is the procedure once it comes from the custody and the proper source, then what are the ways forward once the document is more than 30 years old, and what is the significance. Wills, as we all know, wills has their wills, as we all know, has its own significance. As they say in a lighter vein as well as otherwise, where there is a will, there is a way. Meaning thereby, one who has got a strong will can achieve what he wants. And when there are wills, they can always attract the relatives. And they say one who has got a lot of a will with a lot of property, then he has got many friends and many relatives. But there arises a issue. They say once you have a good will, then the lawyers at the same time are the offshoots of that, who also enjoy that particular part of some enrichment directly or indirectly, in a lighter vein, we can say. Because once there is a will, there is bound to be some litigation, and once section 90 or any other Evidence Act provisions come into being. Because once it is peaceful, then the question of issues regarding the wills don't arise. And as in the other professions, they say, the lawyers or the professionals thrive upon once there is a difference. But nobody as such wants that there should be a difference, because even for the drafting of will, nowadays people contact the lawyers. So without taking much time, we all know that Mr. K. Prabhakar is a speaker with immense knowledge of law, and the way he conveys and canvasses his points, not only during the court, but also during these webinars and seminars, is a point, as they say, hitting the nail right on the top, or as we say, strike when the iron is hot. To understand the nitty-gritties of all these aspects, there couldn't be a better speaker than Mr. Prabhakar, who is well versed in these subjects. As such, we requested him, and he was kind enough to accede to our request to share his knowledge. As we always say, that sharing is caring, and especially during these testing times, it's a different facet. Without taking much time, I would request Mr. Prabhakar to take over and give us the insights of a topic which everyone is keen enough to learn about it.
Thank you, Mr. Vikas. It's a great opportunity for me to address the aggregator during pandemic 19. If there is a will, there is a way. But unfortunately, under section 90 of the Evidence Act, it is the will of the court that will have its weight. Take it in the lighter way. The presumption, which is now being focused on the section 90, with regard to a will, quite strangely, is not being applied in case of a will, whether it is a original or even a copy of that will for that matter. For more than a century, the settled position of law is that if an original will is produced from a proper custody, and if it is an ancient document, namely under the Act 30 years, in case of 90 and in case of UP amendment, it is 20 years. Then the court can presume not only the signature found in the will, but also the sound disposing state of mind of the testator and also the contents thereof. That was the position which stood the test of time and to my memory from 1873 till 2009, when there was a sudden change in the perception by the Supreme Court, which necessitated this discussion because of the reason that when Supreme Court in 2009 came out with the decision stating that in case of a will, the presumption under section 90 does not apply, which was subsequently followed in 2013 by the Supreme Court and by the various high courts, have started following this mechanically, if I needed to say so, that in case of a will, the question of applying section 90 of the Evidence Act doesn't apply. The reasoning given by the court subsequent to the Supreme Court decision in 2009 and 2013 is that in case of a will, there is a special provision under section 63 of the Indian Succession Act as well as section 68 of the Evidence Act. And if the attesting witness is not found or not capable of being produced before a court, the procedure given under section 69 of the Act as well as section 70 of the Evidence Act will come into play. Therefore, the question of applying section 90 of the Evidence Act to presume an ancient document does not apply to a will. Quite unfortunately, in 2009, when the Supreme Court considered this matter, it did not even went into the earlier precedents which were available readily and which was applied for more than a century by the courts in India as well as by the Privy Council before independence. We can find from the judgment in 2009 Supreme Court that it was a case of a refusal by the Honorable Supreme Court to exercise the discretion. But the wording was not happy, and we have started interpreting as though section 90 cannot be applied in case of a will. Now for the past 11 years, we are in a conundrum that in case of a will, even if it is an ancient document, you cannot invoke the presumption under section 90. Is it correct? This discussion now turns around by tracing the history in respect of section 90 of the Act and how the Supreme Court has made a mistake, a grievous mistake I would say, in 2009. The first case to my mind, which in which this presumption was invoked, is way back in 1873. A decision of the Privy Council in Rajendranath Holder versus Jogendranath Banerjee, reported in 14 Moore's Indian Appeal, page 67. Before going into this case or the facts of the case, we will now deal with how this section 90 will apply with a particular reference to section 65 and 68 of the Evidence Act. We can find under section 3 of the Evidence Act, a document is defined that any inscription, even in a inscription in a writing, lithography, or engravement in a stone or a tree can be called as a document under section 3 of the Evidence Act. Section 65 speaks about, 63 speaks about the primary evidence. 65, now 60 becomes a 65A, about the secondary evidence. Section 68 speaks about the mode of proving a document which requires attestation mandatorily or compulsory. Section 63 speaks about a primary evidence. If a document is there, you can file it. Section 65 speaks about the circumstances under which a secondary evidence in the absence of an original can be let in as evidence. There are several categories. One is that if a document is in the hands of the other man, or if the document is lost or destroyed, or if the document or the execution of the document is admitted in writing, or when the document is not movable. Suppose you say that a particular document is a tree or a stone inscription. You can't bring the inscription to the court or carry the stone. It is so huge. Therefore, that exception is also available under section 65. Secondly, when this type of secondary evidence can be let in some cases, like if the document is lost or destroyed, any secondary evidence is admissible. In case of original, if it is available with the opposite party, by serving a notice under section 66 of the Evidence Act, you can let in a secondary evidence. And in some cases, a certified copy is also admissible, provided a certified copy is a document under the Evidence Act or any other act in force. The point at issue is section 63 speaks about the primary evidence. Section 65 speaks about the secondary evidence. Section 68 speaks about the mode of proof in respect of any document for that matter, whether it is an original or even a copy of thereof. It says that in cases of a document which requires attestation, the document is admissible in evidence provided at least one attesting witness is examined if he is available and subject to the process of the court. But there is an exception, namely in case of any other document except a will. If there is an admission by the party, then you are relieved of examining an attesting witness. This section 68 can be applied to very many documents. What are the documents for which section 68 can be applied? In case of, obviously, in case of a will, gift, mortgage. These three documents are compulsorily requires attestation, including gift. The point at issue is, if it is a gift, mortgage, or a will, and if it requires compulsorily an attestation under the Act is by at least by two witnesses who see the executant signing or affixing his thumb impression, and they have his executant's signature or the thumb impression has been acknowledged by the executor himself, and having got the acknowledgement, the attesting witness have signed or put their signature or their mark, namely the thumb impression. These things have to be proved in a court of law when the document is being subjected to a challenge. But in case of a will, there is an exception under section 68, namely even if the document is admitted by a party or the execution is admitted by a party, then notwithstanding the fact that there is an admission, the court has to see that an attesting witness has been examined. If it is a will, it is a mandatory. If in case of a gift or a mortgage, and if there is an admission, there is no problem at all. If 68, he says that the mandatory and attesting witness has to be examined, and if the attesting witness is dead, circumstances 1, if the attesting witness is dead, 2, if the attesting witness is not available or not subject to the process of the court. In 2 cases, what you can do? Law says that you have to invoke section 69 and 70. In case of section 69, if the attesting witness is not available or is dead or not subject to the process of the court, then you should be able to prove that the signature found in the document, namely that of the executant and that of the attesting witness, are that of the executant and the attesting witness. How it can be done? By examining a person who is acquainted with the signature of the executant, or in case of attesting witness, that attesting witness, that that can be cured. Recently, a judgment came that in cases, this consists of two parts. One is the signature or the thumb impression of the executed. Two, signature or the thumb impression or a mark of a attesting witness. Both these things have to be proved. How it can be proved? It can be proved by examining a person who is acquainted with both the signatures, or by a person independently. One may be acquainted with the signature of the executed, and another may be conversant with the signature or the thumb impression of the attesting witness. In such cases, you have to examine both. Otherwise, you will not be in a position to prove the document. This is the scheme of section 69. 70 says that if a document requires attestation and if it has been attested, if it doesn't require attestation and if it is attested, it can be proved by a mode by which a document can be proved as though this document is not requiring any attestation. This is section 68 and 69, 70. Section 68 also corresponds with the section 63 of the Indian Succession Act. A very similar provision. Now coming to section 90. What the section 90 says. Section 90, the opening sentence is very important. Section 90 would say, where any document purporting or proved to be 30 years old is produced from any custody, which the court in the particular case considers proper, the court may presume that the signature and every part of such a document, which are purposed to be in the handwriting of any particular person, is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the person by whom it purposed to be executed and attested. Explanation is also very vital. Documents are said to be in a proper custody if they are in the place in which, under the care of the person with whom they would naturally be. But no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render such an origin probable. What it says, section 90 speaks about any document. The opening sentence is where any document is 30 years old. The point is therefore, if a document is 30 years old, then we can invoke the presumption under section 90. But of course, this presumption is only a discretionary presumption where the court has to exercise the discretion in the circumstances of the case. Two, the custody of the document is also important. The document, if it comes from a proper or an appropriate custody, then we can say that the first limb has been satisfied, that the custody is from a proper person to whom this document belongs, or in the normal course of circumstances, it will be having the custody of the original. Suppose that one of the beneficiaries holding the document. This is an exception. Normally, the courts are not concerned with the person who produces the document. The custody is irrelevant. The theory is beg, borrow, or steal. The courts are not concerned about that. The court is more concerned about the genuineness of the document. We can very well say that this has also been observed by the Honorable Supreme Court when the Rafah gun was under challenge. A document was produced in court and the government objected to the same on the ground that the entire document was not produced before the court, and the note of the then defense minister, Mr. Prabhakar, which was there, it has not been filed into court because the truncated document was filed into court. Then the court asked one question: whether the contents of the genuineness of the document are you challenging? We are not concerned who has produced it, whether it is a confidential document or not, we are not concerned. We are concerned with the genuineness of the document. The theory is, in all cases, the courts are not concerned with the source of the document. Beg, borrow, or steal. You can file the document, but Section 90 of the Evidence Act is an exception. Under Section 90, the explanation shows that unless it comes from an appropriate source, the court cannot presume. Because it relieves you of the mandatory provision under Section 63 of the Evidence Act, Succession Act, and 68 of the Evidence Act. Therefore, first limit, you have to satisfy the court that it has come from an appropriate source or a custody. And the explanation also says that a probable cause is shown that it could have been with this particular person, then we cannot say that it is not a proper custody. That is all, it depends upon the facts of the case, we cannot go. The second point is, Section 90 doesn't speak about any specific document. It says where any document. I can draw inspiration from some of the judgments of the Honorable Supreme Court when they have interpreted Section 35 of the Indian Stamp Act, when any purpose has been interpreted as including a collateral purpose. If you want to use the document for any purpose, then you have to affix the stamp duty in respect of the purpose for which the document has been executed, whether it is for a collateral purpose or for a money transaction. The court is not bothered, but you have to pay the stamp duty or you have to pay the stamp penalty. Now this any, which can also, we can draw inspiration from those judgments, that when Section 90, the opening word is where any document. Does it mean that it will exclude a will? You have to just box this Section 90 with the Section 68 of the Evidence Act. If you read Section 68, there is an exception in the explanation where it will say not being a will. Namely, in cases where a party, opposite party comes and admits the execution of the document, not being a will, then you will be relieved of the mandatory provision to examine an attesting witness. The framers have thought it fit that this should not be allowed in case of a will, because the court has to apply the theory of armchair. Namely, the court has to sit in the position of a testator to find whether this testator would have executed this type of a document. Normally, a will speaks from the grave. Therefore, the executant is not before the court to speak about the genuineness or the validity or the intention to execute such a kind of a will. Therefore, the court has to be conscious of the fact with regard to the will. And there are very many cases where we find that if there is any suspicious circumstances, the courts are bound to look into that and you have to remove the suspicious circumstances. But the point that issue is, when Section 68 speaks about a case where an exception has been carved out, namely that in case of a will, admission is not enough, you have to prove by examining an attesting witness, whether the legislature would have thought it fit to not include that such a provision in Section 90 when it speaks about where any document. My view is that the object of Section 90 has to be seen. An ancient document, how it can be proved? Assuming for a moment a document is being challenged after 900 years, can you find anybody, any attesting witness to speak about it? 2, can you find anybody who is acquainted with the signature or the thumb impression of the executant or the attesting witness for that matter? If the view of the legislature is that it is well nigh impossible to produce a witness attesting witness or any witness to prove the signature as contemplated section 69. Whether this problem includes the case of a will or not. My submission is that even in case of a will, we come across this problem. If you say that section 90 cannot be applied to a case of a will, then a dishonest litigant, what he will do? A dishonest litigant, if he knew that the will is true, will keep quiet and allow his grandson to challenge the same after 40 years or 50 years, so that the man who is a beneficiary under the will be handicapped in producing the witnesses to prove the will. That cannot be the object. Therefore, the point for consideration is that even in case of a will, section 90 should apply. Now we will see the first of the cases which came to the court in 1873. There is an interesting case in the sense that that case came before the court much before the Indian Evidence Act, the present Evidence Act of 1872. But the case was decided by the Privy Council after the advent of the Act. They were conscious of the fact that in case of the will, it may not be possible to prove the execution if the document is old or ancient. And now cite this judgment which I referred earlier, Rajendranath Holder versus Jogendranath Banerjee, 14 Moores Indian Appeal, page 67. Very interesting case in the sense that was a case where the will was challenged and produced before the court within 27 years, not 30 years. Because this is not a case covered under the New Evidence Act 1872, a case which arose before that. So a couple of decisions of the English courts of 1850, if I remember, was cited in the judgment and said that a document which is old, the rigor of asking a party to produce an attesting witness is well-nigh impossible. And therefore, the presumption with regard to the due execution as well as the sound disposing state of mind as well as the contents of the document has to be taken. Remember, there is a case which came to the court in 27 years of the document being executed. That was the first case. The people were under the impression that under the Evidence Act 1872, this provision being clear, it will apply to the case of a will. Now there are two things available. One is, if an original is produced before a court, and the another is if a copy is produced before a court in the absence of an original. In case of an original, the courts have consistently held that a presumption can be drawn even in case of a will till 2009, when bar opposing case came to the court. But there is somewhere down the lane from 1873, when Rajendranath Holder case came to the court, a distinction was sought to be made, namely that presumption can be raised in case of the original and not in case of a copy or a secondary evidence. How it came? It was in the case of Sitaya versus Subramanya Somayadu, reported in ILR 52 Madras 453. The decision of the Privy Council, ILR 52 Madras 453. Somewhere in 1929, that case came to the Privy Council. In that case, it was a case of Inam grant and not a case of a will. However, the court has held that section 90 has to be applied. There was a discussion with regard to two things. One is the original Inam grant was not filed into court. yes, certified copy was known as being filed as secondary evidence was let in, whether the provisions in the section 90 can be invoked in case of a secondary evidence. And if the secondary evidence is admissible, what purpose you can admit the document? Namely, there are two parts in a case of a document, namely signature form and the contents thereof, as well as the sound disposing state of mind. What the courts have now held that in case of a secondary evidence is being let in the absence of an original, and if it is a 30 years old document, then you can presume the signature and not the sound disposing state of mind, or even for that matter the contents thereof. If you read section 90, 90 speaks about the due execution, the presumption in case of a due execution, presumption in case of a sound disposing state of mind, presumption in case of a contents of the document as well. But somewhere down the lane, the courts have held that if you file only a secondary evidence, even if you satisfy all the ingredients as contemplated under section 65 of the Evidence Act, even then the court can presume only the signature. How it has happened? This is the case. Sitaya's care, ILR 52 Madras page 453. It was a case of an Inam grant. A secondary evidence was let in, and the court found that you can presume the signature. I went into the judgment. You can find in the judgment there are discussions about the signature as well as the contents. In one paragraph, it presumed that the signature should be presumed. That's what the court said, that because it is a signature in a document can be presumed under section 90. And in the next paragraph, the court said that we can presume the original grant, namely the terms of the original grant can be presumed. It is in para number 2 and 3 of the judgment. In para number 2, it says that under section 90 of the Evidence Act, you can presume the signature. And in para number 3, it says that the secondary evidence has been let in, then the terms of the original grant can also be presumed. Terms is the conditions or the contents thereof. Quite unfortunately, this judgment was interpreted by the very Privy Council itself in a subsequent judgment, that you can, this judgment refers only to the signature of the document and not to the contents of the document or the terms of the grant. How it has happened? You can find now the next judgment, a very interesting judgment, which arose from Allahabad High Court. Kunwar Brijraj Saran Singh versus Kunwar Basan Singh, 118 Indian cases 154. This was a Kunwar Brij Saran Singh case came before the Allahabad High Court, and subsequently the matter went to the Supreme Court in 1930, to the Privy Council in 1935. This case was decided by the division bench of the Allahabad High Court. His Lordship Sulaiman, he discussed the entire wealth of material available from Rajendranath case 1873 MIA up to 1929, including Sitaya's case, and said that a secondary evidence, if a foundation is laid under section 65 of the Evidence Act, even in case of a will, you can raise the presumption. Of course, there is a discretion available. What is this discretion? Suppose if you bring in material that this document, notwithstanding the fact that it is an old document or ancient document, there are suspicious circumstances, namely with regard to the signature, or the ink, or the disinheritance, etc., or in the sound disposing state of mind of the testator, the court can refuse in an appropriate case to raise the presumption as the party to prove the document. But that discretion rests with the court. Whether or not they exercise the discretion, justifiably so, it can do. But the problem is you can't shut that the court cannot can take the secondary evidence at all. But in this case, when the Allahabad High Court decided in 1929 that the secondary evidence is admissible, the matter went to the Privy Council, reported in 1935, MLJ page 225, Privy Council, 1935 MLJ page 225. That was the first melting point in respect of a bill with a particular reference to section 90. What happened was this. The Privy Council referred to Sirayya's case. Even before the Sirayya's case, there was, if I remember, there was another case of the 3 judges, wherein the presumption was raised in case of a bill also. But 1935, the Privy Council read para number 2 of Sirayya's case and not 3, and held that in Sirayya's case, the court has held that section in case of a bill, if a secondary evidence is produced before court after laying the appropriate foundation to receive the secondary evidence, even then it can only presume the signature and not the content thereof or the mental state of mind of the testator, etc. That is the first deviation which one could see. But remember that even in that case, the court has raised the presumption with regard to original. It says that only in case of a secondary evidence, you cannot raise the presumption of section 90 in respect of the contents or the sound disposing state of mind, not about the signature form in the document. Therefore, an exception was carved out in 1935, but wrongly so in my opinion, because Sirayya's case never said that you cannot let in any secondary evidence at all. Once this judgment came, people were under the impression that the 90 will apply in case of original and not in case of a copy. In case of a copy, the contents or the mental state of mind of the testator cannot be presumed. Then another case came very interestingly before the Privy Council, reported in AR 1947, Privy Council page 15. AR 1947, Privy Council page 15. A decision in Munna Lal versus Mohammad Kashi Bai. Munna Lal versus Mohammad Kashi Bai. An issue was framed specifically whether the provision of the section 90 of the Act to raise a presumption will apply in case of a bill. If you go through the judgment, you can find that a specific issue was framed by the Privy Council and answered in affirmative, stating that if the original bill is filed, then there is a presumption under law. The court can, in appropriate case, exercise the discretion to raise the presumption and ask the party who challenges to bring in some material to challenge this same. Subsequent to this judgment, there was another judgment of the Honorable Supreme Court in AR 1954 Supreme Court, page 606, namely Sittal Das versus Centram and others. Sittal Das versus Centram and others. AR 1954 Supreme Court, page 606. That was a decision of 4 judges. Those days, Supreme Court sat in 4 because if I remember correctly, in the earlier part of the formation of the Supreme Court, we have 9 judges or of them 11. Therefore, some of the courts are sitting in 4 judges rather than now 3, 5, 7, and 9, etc. But in that case, a certified copy was filed, not the original. The court went on to rely upon the decision in Munna and has also referred to the decision in Kurwar Basan's case in 1935, wherein the Privy Council has held that in case of secondary evidence, only the signature can be presumed. If you go through the judgment, the courts have accepted the proposition that in case of an original will, the presumption of section 90 can be taken. But that is on facts, it's a refusal to take the presumption as the original was not filed, a secondary evidence alone was filed. But the bottom line is very clear that 4 judges of the Supreme Court has held that in case of an original, the presumption can be invoked. Subsequent to this judgment, there was another judgment in AAR 1968 Supreme Court, page 947. Kalindi Venkata Subbaraju versus Sindalapadi Subbaraju. Kalindi Venkata Subbaraju versus Sindalapadi Venkataraju. That was a case of 3 judges of the Supreme Court. That was also a case of a certified copy having been filed into court as a secondary evidence. The court said that in case of a secondary evidence, the court cannot invoke the provisions under section 90 of the Act. But the court went on to say that if an original is filed, then you can raise the presumption. As in this case, only a certified copies are not being filed, we can't invoke the presumption with regard to the sound disposing state of mind or the contents of the document which the party is liable to prove. That is in 1968. This, therefore, the position almost for 70, 80 years got settled. Namely, that if you follow original, then the court can presume the signature, contents, mental state of mind, as well as the signature of the attesting witnesses. After this 1968 judgment, there was a judgment in 1995 Supreme Court, I'm not able to locate the judgment, where it was a case of a sale deed. The court relied upon the judgment reported in the AR 1968 Supreme Court and held that in case of a original, even though it is a case of a sale deed, and if your original is filed as found in AR 1968 Supreme Court, you are entitled to invoke the presumption. But if a certified copy is filed as secondary evidence, you can't invoke the presumption with regard to the terms of the grant or the terms of the document, as well as the mental state of the testator or the executant for that matter. Therefore, it's all settled that if you file an original, you can take it for granted that in an appropriate case, if you produce it from a proper custody, because you have to satisfy section 90 of the Act, namely you have to produce the from a proper custody, and if the custody is there proper, then the court can exercise its discretion to raise a presumption. What is this exercising a discretion? As I said earlier, that if there are material available to throw some suspicion with regard to the sound disposing state of mind, or with regard to the disinheritance, or with regard to the variation in the writing or the ink or a document being tampered on the face of it, the court find that you can't rely upon this document, then you can't compel the court to raise the presumption. Assuming for a moment if that discretion is not available, the law says that court may presume. If you compel the court to presume a document, and even if then in all cases where there is some suspicion, the party who wants to challenge it will be in a real handicap. Therefore, the law is very careful that it doesn't allow you to allow the court to take a presumption mandatorily, but it gives a discretion to the court. This discretion, a well-laid parameter, justifiable parameters available for the court to find whether we can invoke this presumption or not, or ask the party to prove it. Practically, we find that the no trial judge said that I won't raise that presumption, you must prove the document. We all come to the High Court of the Supreme Court, and then we challenge it that the decision of the trial court is not correct. the trial courts nowadays doesn't reveal its mind that these are the circumstances which impel me not to invoke section 90. Go ahead and prove the document. What the lawyer would do, he will presume that he can invoke section 90, and therefore he will not take any interest in proving the document, and subsequently he will be handicapped before the High Court. Oh, this document has not been proved, the court has not raised the presumption. Therefore, a lawyer must be very careful in analyzing the document, scrutinize the document, and find whether you can convince the court to raise the presumption under section 19. And if you have any doubts that you can't convince the court, then you should be very cautious in relying upon section 90. Rather, it is better to let in some evidence to prove the document. Now the question will arise. Suppose a document is 30 years old, and you find that the document may be challenged on some ground, and therefore I have to take the chance of proving the document. Proving the document. How you will do? Section 69 speaks about the absence of a witness and how you have to prove it. It can be by way of a scientific expert or by anybody who is acquainted with the execution of the executant signature or the attesting witness signature, etc. Once the lawyer takes the call to prove a ancient document, and if he fails, you cannot ask the court to raise the presumption under section 90. Be careful. It is not possible. If you want to raise a presumption under section 90, the entire burden is not on the parties, but on the lawyer who projects the will to take a call whether I can invoke section 90 and raise the presumption and ask the court to request the court to raise the presumption, or I have to necessarily prove the document in a manner known to law as contemplated section 69, 70, 71, 73, etc. 73, etc. But the point issue here, the court says here that once the party takes a chance of proving the document by letting in some evidence, and if he fails, then he cannot turn back and raise the presumption under section 90. Huge call for a lawyer. Huge call for a trial lawyer, that too. The point is, can we take such a chance? If I don't examining an attesting witness, or if the party is not available, dead, I can ignore the provisions of section 69, 70, and then request the court to ignore the provision under section 90. The problem is that it is a call of the lawyer and the lawyer alone. The parties are, in many cases, they do not have the legal nicety to decide all these things. A huge burden is on the lawyer to take the call. Please do remember, once you take the call and let in evidence, forget section 90. That is in respect of any document, whether it is a will or a mortgage or a gift. Now coming to AIR 2009, Supreme Court page 1766. Barapur Singh versus Samsher Singh. This raises the controversy, and the entire wealth of judgments, starting from 1873 till 2009. I can now recall 1873 by 5 judges of the Privy Council. Sita's case is the 5 judges of the Privy Council. 35 Privy Council, Banwar Singh, Kumar Saran Singh case, 5 judges. AIR 47 Munala's case, 5 judges. AIR 1954 Supreme Court Siddhartha's case, 4 judges. 68 Supreme Court Kalindi Venkata Subbaraju's case, 3 judges. All have held that section 90 can be invoked in an appropriate case in case of a will also. Then how would the law has changed? The Honorable Supreme Court in Bharapur Singh case has held that the Section 90 doesn't apply in case of a will. I will read only the 3 or 4 lines of the judgment which is relevant today from the judgment, and you will find that the observation of the Supreme Court, with due respect, is erroneous, incorrect, and has caused an immense hardship to the litigants. I will come there how it is causing immense hardship. Now read these 4 lines of the judgment. I will read now for the benefit of the viewers, my friends. The provisions of Section 90 of the Indian Evidence Act, keeping in view the nature of proof required for proving the will, have no application. This is a death knell. Death knell. Read the next line. A will must be proved in terms of Section 63C of the Indian Succession Act 1925 and Section 68 of the Indian Evidence Act 1872. In the event the provisions thereof cannot be complied with, the other provisions contained therein, namely Section 69 and 70 of the Indian Evidence Act, providing for exception in relation thereto would be attracted. No judgment of the Privy Council or the Honorable Supreme Court was referred to. That was a case where the court refuses to exercise the discretion. This was the judgment of His Lordship S.P. Sinha. I can never imagine that His Lordship Sinha would have said that Section 90 would not be applied in case of a will. He was a great judge with a great knowledge of civil law. Therefore, it was never in his mind that he is laying down any law stating that in case of a will, Section 90 cannot be applied at all. Then how it has happened? That was a case where the court refuses to exercise the discretion. Why it has refused to exercise the discretion? The court finds that the discretion, the law says that the court may presume. In an appropriate case, it can may presume. And in cases where it can't justify in raising the presumption, then you can't raise the presumption. In that case, evidences are let in to show that that all is not well in the case on hand in that case. The testator was not in a sound disposing state of mind. Evidences were let in that he was sick before his death. There was only a short period with which he passed away, the testator passed away. Therefore, what was in mind of the Honorable Supreme Court is that he doesn't want to exercise the discretion. But unfortunately, the paragraph which I have read from the judgment says 2 things. That the provisions of Section 90 of the Evidence Act, keeping in view the nature of proof required for proving the will have no application. Why it is so? That Section 68 speaks about even in case of an admission by a party, your party will be relieved, the other party will be relieved of examining the attesting will, but it will not apply their will. In case of a will, you must examine. Keeping the provision in mind, the court said that in case of the will, Section 90 not apply. But the next reasoning given by the Honorable Supreme Court is erroneous. In a sense, what it said, that taking into account Section 63C of the Indian Succession Act 1925 and Section 68 of the Indian Evidence Act, in the event of the provisions thereof could not be complied with, there are other provisions, namely 69 and 70 of the Act. Therefore, 90 would not be invoked. I am astounded, dumbfounded, rather. The reason is, it is not only in case of a will, in all cases coming under section 68 of the Evidence Act, if you are not able to prove the document as contemplated in section 68 by examining at least one attesting witness, as the attesting witness is dead or not subject to the process of the court, then you can take the aid of section 69. Section 69 says that somebody is appointed with the signature. Will it not apply to a mortgage? Will it not apply to a gift? In all cases covered under section 68, if you are not able to examine an attesting witness, then you can invoke section 69. But if a gift or a mortgage, a presumption can be raised under section 90, and if the logic given by the Honorable Supreme Court that in view of section 69 and 70, the provisions of section 68 cannot be watered down, is wrong in a sense. Section 68, 69 and 70 apply equally to a mortgage, gift and a will. Therefore, the logic is highly illogical. The Honorable Supreme Court probably would have held that there was a case of a refusal to exercise a discretion and not a case of not a case stating that section 90 cannot be invoked at all. It is rather a case of refusing to exercise a discretion. Then what will happen if this judgment comes? Yet another judgment of the Supreme Court. That made us how the litigant and the lawyers will address the claims. M.B. Ramesh versus Veera J. AR 2013 Supreme Court. AR 2013 Supreme Court page 2088, 2088. M.B. Ramesh versus Veera J. There is a case where His Lordship Gokhale has followed AR 2009 Supreme Court Bharatpur case and held that the Supreme Court has held that in case of Bill section 90 will not apply. Therefore, I don't want to apply section 90. There is a case of a original. There is a case of a original. The court refuses to raise the presumption. Then the floodgates are open for all the high courts to follow the decision, except in one decision, if I remember correctly, of His Lordship Kaur, sitting as a Delhi High Court judge, along with another judge, they held that the judgment of His Lordship Sinha in AR 2009 Supreme Court ultimately turned on facts as a case of refusal to exercise the discretion. The court found it is very uncomfortable to make a comment. Sitting as an High Court judge, they were not able to comment upon the Supreme Court judgment, but said that that is more on facts and rather than on law. But the point is, once this judgment came, all other high courts started following this judgment and said that in case of a will, section 90 doesn't apply. Then what is the law as of today? And what is the problem which the litigant faces in court? Before 2009, presumptions are raised, at least in case of an original. If the original is not produced and the secondary evidence is produced, the first part will be satisfied, namely the presumption with regard to the signature will be there. But the party has to prove the other things with regard to the sound disposing state of mind and the contents of the document. And this judgment was being followed by all the subordinate judiciary until 2009. Many of the cases, presumptions are raised, and many of the cases are pending before the higher courts, I mean even high courts. Now suddenly this judgment came in 2009. stating that section 19 doesn't apply. What will be the fate of the litigant who have filed the cases, relied upon section 19 and got the benefit of this section also before the trial court or the first appellate court, and the matter being pending before the High Court or the Supreme Court without any clarification as of today? For the past 11 years, we are mechanically following AR 2009 Supreme Court and AR 2013 Supreme Court, and you can very well see that many of the High Court, including our own High Court, my own High Court here at Madras, there are several judgments which is saying that you cannot apply section 90 at all in case of a will, invoking section 2009 Supreme Court. But none of the judgments have considered the history of section 90 or the object of section 90, or the judgments from 1873 in Rajagannath's case till Kalindi's case in 1968 Supreme Court. A large number of judges, namely 4 judges, 3 judges, 5 judges, have held that a presumption of section 90 can be applied. Then how the lawyer can go about once this situation has come, and what is the way out for him? Suppose the case is before the High Court, where before the trial court, a lawyer has invoked this provision of the section 90, and the court has also accepted the same, and subsequently there is a top 6 survey. What a lawyer can do? There are 2 things open for him. One is to argue that AR 2009 Supreme Court and AR 2013 Supreme Court are wrong and erroneous in view of the earlier precedents, one of larger benches. Therefore, these 2 judgments should not be applied. But I am afraid that many of the High Courts are very reluctant to do it because they follow the recent judgment instead of following the precedent, well-established precedents. What is the precedent? The precedent says that if there is a larger bench covering in the area, then you have to follow the judgment rather than the latest judgment. Quite unfortunately, 2009 Supreme Court or 2013 Supreme Court did not even consider any of the earlier judgments of the Supreme Court or the Privy Council. Nobody brought to the notice of the court. I'm not sure why it has not been done in 2009, but I am also not sure why in 2013, when the matter came to the Supreme Court, nobody had got the guts to say before the Supreme Court that the AR 2009 was wrong. Nobody has referred to the earlier judgments. The court was not informed about the earlier judgments, and therefore it has simply followed AR 2009. And now all the High Courts, probably with the exception of Delhi, where his Lordship Sunday Golan, if I remember, but has made a distinction that 2009 is not on that point. It is a case of a discretion or a refusal to exercise a discretion by the court. Now coming to the next point, if you are not able to convince the court before the High Court or the First Appellate Court that already section 90 has been invoked and the matter is pending, what is the way out for the litigant who relied upon section 90 and in a catch-22 situation? The only point available remedy is go before the court. If the Lordship is going to agree with the judgment in 2009, I was conducting the case under the old law or the law as laid down by the Supreme Court and the Privy Council earlier, and kindly remand the matter to the trial court so that give an opportunity for me to fulfill the ingredients. Point number 3. Assuming for a moment you go back, will you be able to prove? Suppose a document is 100 years old. What type of evidence one will be able to bring to the court to prove a document? Will it not give an incentive for a dishonest litigant to go before the court and wait, or rather wait for the right time or the tide to turn in his favor, and allowing his grandchildren to challenge the document after 50 years or 60 years, so that there won't be any witness to prove the same. That cannot be the intention of the legislature. Therefore, my view is that these two decisions have unsettled the well laid out position of law, which has stood the test of time for more than 100 years. And we all know that if a particular judgment is being followed, or a position of law is being followed by very many people in this legal society for a long time, the court must be reluctant to change that view. I can remember in one case, a judge has given a dissenting view, but the majority judgment was being followed as right for a long time. Subsequently, an opportunity came for him after he being elevated, and the people asked him to reconsider the decision in the light of his own dissenting judgment. There was a dissenting judgment of your lordship. Your lordship can now reconsider the issue because there is an opportunity, a big leap. To say with the greatest respect, the judge, I don't want to name his name, he refused. He said, I have got my own opinion, but the law has been settled and settled for quite a long time. I should not express my view to change or unsettle the issue. He refuses to entertain such a plea. And if I remember, Lordship Venkatachalayya, the retired judge of the Honorable Supreme Court, said that prejudices and personal views of the judges became the law of the land. That judge was an exception. And he has said that we can't do that. I may have a different opinion, but once a judgment has come and it has been settled, it is quite inappropriate for us to unsettle the issue. Therefore, once this AR 2009 is shown to be wrong, or more likely misunderstood by the High Courts. It's not that we can say that the judge was wrong in pronouncing the judgment. Maybe not happily worded, but it was a case of interpretation of the judgment made by the subsequent judges that made it more difficult for us to digest. The reason is that it was a case of a refusal to exercise a discretion. That wording was not there in the judgment. I don't want to exercise the discretion because of the facts and circumstances or the factual background. Then that is the matter. But now the Pandora's box has been opened for 11 years. We are not in a position to canvass this or rely upon Section 90. It's an option choice for a lawyer who presents a bill which is of an ancient document to prove the document. How it is possible to prove? The very logic of applying this presumption in case of a gift and mortgage will not the very same logic apply there. What is the logic? The logic is, if the document is old, then the party may not be able to produce any witnesses or the evidence for that matter to prove a document. If it applied a gift or a mortgage, why not a will? The problem is there that for past 11 years, we are in a position not to give any opinion on that score unless it is being clarified by another Supreme Court judgment. And in fact, an opportunity came, and I want to share my views on one of the judgment in Srirangam Building Society's case, which was decided by His Lordship Akbar Ali in Madurai Bengali Madras High Court. I took the matter to the Supreme Court. His Lordship Singhvi said that the point is correct, but I am dismissing the appeal at the admission stage on some other ground. We will see it later. That is in 2012. We are seeing it later. For 8 years, you are not in a position to get any clarification of that score. Hopefully, there will be some judgment which comes up. The lawyers who take give a clarity to the issuance, to give a finality. The reason is, once a judgment, provision which has been followed or a legal position is followed for 100 years, and you cannot, by one stroke of pen, change that law, make the litigant suffer. Thank you so much for all my friends to hear a lawyer. We are in a pandemic, and many of the lawyers find it very difficult to learn something, but they can learn something. And I thank Mr. Vikas for giving an opportunity for a village lawyer to give some insight about Section 90 of the Evidence Act, which is relevant, and I hope some of my lawyers' friends will be in a position to take up the matter further so that we get a clarity at least. I thank you, sir. I thank you, everybody.
Mr. Prabhakar, first of all, if you have come from the village and thereafter you have been taken up to this thing, it gives a hope to a lot of people that one can reach to the pinnacles. It's the only the will and not the will to rise. That's paramount. So that becomes a facet. But I was just remembering, if you remember, when Uma Devi's judgment came, and then thereafter there was a judgment to the effect that the regularization, that the backdoor entry, there was a distinction carved out between the 2006 volume 4 SCT page 1, to the effect that once you're a backdoor entry, then regularization could not be done. Then a 2 judges judgment had said that the Uma Devi's judgment will not apply because Maneka Gandhi speaks of more facets of fundamental rights. Therefore, to that effect, Uma Devi is not binding. But ultimately, the 3 judges judgment, probably by Justice Singhvi, came in, which it said that as long as there is a larger bench judgment, the 2 judges judgment cannot say to the effect that this judgment is not fine. I think that 2009 judgment, if somebody gets that gets a case, he can always refer to the effect that once there is a larger judgment, irrespective of the latest precedents, it doesn't matter. Number 2, there is a judgment of our High Court, that is the NSWIFT, because there is also a divergent view. Let's assume there are 2 division benches or 2 coordinate single benches having a judgment. Then which to follow? Some judgments say that you have to follow the latest judgment, but our full bench says, in Swift's case, it says that you have to follow which is correct in accordance with law. You can say that you may not write directly that it's a per incuriam judgment, but still you can say that since the larger judgment is not referred to, therefore the larger judgment will bind me rather than the latest judgment. That is personal my take. But we can take questions. This is by, first I will take from the Facebook. This is by Kakli Chatterjee. If probate has been granted and the prosecutrix is not handing over the possession to the beneficiary, how can the beneficiary get his property given by his father?
I'm not able to hear.
This is not exactly from Section 90, but it says if probate has been granted and the prosecutrix is not handing over the possession to the beneficiary, how can the beneficiary get his property given by his father?
Then you have to go to the civil court. Yeah, you have to go to the civil court and get possession. The probate court cannot do it. Probate court has got a very limited role in finding that the will is true, or grant a probate. There ends the matter. Then if somebody else is in possession of the property, you have to go to the civil court and agitate the matter and get back possession. Probate court has no jurisdiction at all.
Yeah. As you were saying that the will is important, that you should have a will while writing the will. Because in a lighter vein, it was said that a person who kept on changing the will, ultimately ending up shelling out the entire property to the lawyers rather than actually creating a will.
You became a sharer or a beneficiary, major beneficiary rather.
So we will this is by what I was saying. Mr. K. Sankaraman also says it's a very impressive and informative. But whether the two authorities which you have been relying upon of 2009 and 2013, aren't they per incurium?
Of course, of course. Yeah, we can even say per incurium, notwithstanding the fact that it is a judgment of the Supreme Court. I can even refer to His Lordship K.T. Sama's judgment and reported in AIR 2000 that a judgment of the Supreme Court cannot be challenged on the ground that it is per incurium. But the problem is, among the Supreme Court judgments, if there is a judgment of a larger bench, then the lower court or subordinate judiciary is bound to follow the larger bench. That is the matter, whether it is per incurium or not, or obiter dicta, doesn't matter at all. But a per incurium judgment of the Supreme Court is binding under Article 141 if there is no other judgment on that aspect. Here is a case that there are a lot of judgments available, even of the Supreme Court, leave alone the Privy Council, from 54 Supreme Court, 68 Supreme Court, etc. Therefore, they are bound to follow the larger bench. There is no need for them to go and canvass it as per incurium.
No, but there are judgments to that effect also, which says judgments are not statutes. Ultimately, the statute will prevail. There are judgments of our High Court which are there to the effect. Let's assume there's a judgment by this thing, and the judge wants to actually carve out the distinction, and then it is again, as we say, all lawyers are the friends of the court. They also have to demonstrate that the statute has not been interpreted the way it should have been, because the judgments which they say, they are only the interpretation of law. But until unless, because 2013 and that Mahinder Singh's Gill's which judgment says, no, not Mahinder Singh Gill's, that Yadav's judgment of 89 Supreme Court on the election petition, which says the law has to be in terms of the instructions and rules alone, and it has to be followed stricto sensu. There cannot be deviation from that.
Yeah, the problem is, once it is interpreted by the Supreme Court, a particular statute, like it should be like this, then no subordinate judiciary can have any different view. I will give you an example. I can give you one example. With regard to Section 6 of the Hindu Succession Act, the court has added words, daughter of a co-partner, meaning by living daughter of a living co-partner. And in Arun Mishra's judgment, he said that the court is not here to add any new words. Until such a time when the Supreme Court clarified the issue, it is very difficult for a lower subordinate judiciary to take a different call or a different view, stating that the statute is like this and the judgment of the Supreme Court is different. I don't want to follow it. You see, that will be a chaos. No? And no judge will do that also.
That's true. This is by Stain Lewis. It is a, I don't know, he has written, it is a Christian succession. One says, defendant advocate has not produced, this is by Stain Lewis, not produced the two testators purposefully for examination. Instead, he produces one of the defendants as a witness for the signature of the executor. Is it correct?
Can I get the question?
I think he has to put it across in more happily worded manner. Stain, if you could put that question in a more happily worded. And I would just request, as per your ease, though we asked you to join us and tomorrow, and you had been kind enough, yesterday, and you had been kind enough, if those judgments could be shared, because I have been receiving the messages on the chat box to the effect that if those judgments could be shared.
Okay.
This is by K. Armstrong. Whether Muslim can execute a will, what is the validity of a Muslim will, whether there is a limitation imposed for a Muslim in an execution of will.
Definitely a Muslim can execute a will provided it is confined to his 1/3 share of the estate. It can't be for the entire estate. It will be restricted only to 1/3 of the estate.
Okay. I will ask. Stainless has again said, Stainless, I can, you will have to post that question again, because at least I have not been able to get it. Just reframe the question. I will see on the, and he says, what is the citation of, by Naveen Kumar, what is the citation of Justice call. You have that idea, the Justice Sanjay Kishan Kaul's judgment? The judgment which you had referred, that Justice Kaul had carved out a subtle difference. This is by Payal Bharat Kotwani. What are the protection clauses to be taken care to avoid the contest of will? Is it audible? What are the protection clauses to be taken to avoid the contest of will?
Protection of
Will. The contest of will. What are the protection clauses to take care to avoid the contest of will?
it all depends upon the facts of the case. The protection is only with regard to the witnesses. We are able to protect the witnesses, provided they are alive. What is the protection clause? You go to the court immediately, get a probate of the will immediately. That is better. Instead of waiting for somebody to challenge it after 20, 30 years, if you want a protection, go to the probate court, get a probate of the will. That is the best protection possible under law, because the witnesses will be available, you can prove it.
What he had posted in a lighter vein, Payal, I remember there's a common joke amongst the lawyers which said that if son comes out, he says in the first year itself, says, Dad, the case which you could not solve it for 25 years, I've been able to solve it in the first year itself. He said that because of that case, you could study. Don't stop closing such cases.
I can also share one thought. One lawyer had a son who became a lawyer, and the first day he went to the court and came back and informed his dad, a case which was pending for 30 years, I have completed today, Dad. Dad said, you are a fool. That was the family silver. How can you finish it?
This is by Stanley. He says, in the absence of the testator, can one of the defendants be a witness to prove the will?
There are two things. One is the attesting witness, and if the attesting witness is not subject to the process of the court, therefore if he is not available in this country, you can't force him to come. Or if the attesting witness is dead, or if one of the attesting witness is dead and one witness is alive, you can examine one witness, it is enough to prove under section 68. But if both of them are dead, or you are not in a position to examine them as they are not subject to the process of the court, or not competent to speak about, namely if he has lost his mental capacity, then you can't examine him. In such cases, law says that you have to invoke section 69. Section 69 says somebody who is acquainted with the signature of the executant and as well as the attesting witness has to be examined. Two parts you have to prove. If you want to invoke section 69, if you are having an attesting witness, examine the attesting witness, that's the end of it. But if you don't have the attesting witness to prove the case, you have to prove two things. One is that the signature or the thumb impression of the executant is in his handwriting or it is his. Two, the thumb impression of the signature of the attesting witness is that of the attesting witness. Two parts have to prove that you may have. Suppose a person is very acquainted with both the executant as well as the attesting witness, then he can prove both. But if the person who is going to be examined is not aware of the executant and is aware or acquainted only with the attesting witness, then you have to examine him and then separately you have to examine somebody to prove the executant's signature. In such cases, two aspects has to be proved.
This is by Stein itself. As a Christian succession in the absence of the testator, can one of the defendant appear as a witness to prove the will?
One of the defendant.
Yeah.
So no problem at all. If there are two things available under law, a party defendant cannot be compelled by the opposite party to be examined. What he can do is, if he voluntarily comes, then you can examine. But you can't compel him by summoning him that he is the only person who is available and therefore I have to examine him. The next recourse is under Order 16 Rule 2 and Order 16 Rule 4 of the CPC, which says that you can take the aid of the court, requesting the court to examine the particular party as a court witness. That can be done on an interpretation. Some of the judgments of the Kerala High Court as well as of the Madras High Court says that that can be invoked by a party after examining or exhausting all the witnesses on either side. After the evidences are all over on both sides, then you can request the court under Order 16 Rule 4 to examine a particular person as a court witness. That is possible under law. There is no bar, but the bar is that you can't compel an opposite party to be examined as your witness.
This is the last question we will be taking from the Facebook. It says by Raju Chandrasekhar. So there are 3 members shown as executors, and can anyone get the probate, or all 3 should apply?
3 members.
Yeah.
Three
are shown as executors. And can any one of the get probate, or all 3 have to apply?
Any one of the executor can go and ask for it. The problem is that some other executor has to be arrayed as a party to the case, probate proceeding, by arraying him as a respondent.
Okay. So thank you, Mr. Prabhakar. The insights topic was spot on. I'm just remembering when there was the famous cricket player Manoj Prabhakar. He was known for his Yorkers. The same way Yorkers, you know that they are all spot on, and the way you took the session, spot on. We all enjoyed the session thoroughly, and it was quite insightful. The will and the another facet of will, as with reference of sections 65, 66. The electronic evidence, we will take electronic evidence on some other day. And then section 90. The entire gamut to be summed up in an hour session, it only speaks volumes of the knowledge which the speaker has. And one can only, as an audience, just try to grasp. It is just like the balls are being thrown fast. You have to see how many balls you can catch up and be ultimately successful. But the topic, the way you explained it, it was a stupendous session which all of us have thoroughly enjoyed on the Facebook as well as on the platform. And I'm quite satisfied that the participants who will watch us on the YouTube channel of Beyond Law CLC, they would also enjoy it. And before we part for the day, friends, tomorrow the session would be concept and computation of damages under the Contract Act by the senior advocate, Mr. R. Murari from Madras High Court at 4 p.m. Do stay connected with us. Everyone stay safe, stay blessed. And again, Mr. Prabhakar, we're all thankful to you the way you have put across the points. I'm quite clear, quite sure that a lot of doubts which were hovering in the minds of the participants would be clear, and there would be a bright sunshine in the minds of them as to how they have to take the case of the will with a greater will. Thank you, everyone.
Thank you.